Our live team coverage continues of the Murdaugh trial, a big ruling issued just a short time ago as it relates to evidence in this case, which, as we have discussed with our expert attorney, trial lawyer Carl B. Grant, is going to be critical. Carl, we were in the studio when we got that news about Judge Newman's ruling as it relates to financial crimes. You say that could be a game changer in this case.
It could be. Number one, it's going to reduce the length of the trial. I imagine the 250 plus witnesses that they talked about, a lot of them were probably related to the financial transaction crimes.
Right, and first for our viewers who didn't hear that ruling, the judge essentially said that those financial crimes cannot be used in a blanketed way as a motive for murder, right?
That's exactly right. And here's the thing, if that's the song that the prosecution has been singing all of this time, and now he can't sing it anymore, what do you have? And here's the thing, I want to make sure it's clear. The prosecution does not have to prove motive in a murder case. You simply have to prove that the person was murdered, it was unlawful, it was killed, unlawful killing with malice or forethought. So motive is not an element of the crime. However, logic is very important in a criminal case. The question becomes, does it make sense? And I can already hear Mr. Harpootla and his team preaching to the jury, does it make sense?
He talked about that a little today.
Yeah, that's great insight there. And we also have more of an understanding of the full list of witnesses that may be called to the stand, including Murdaugh's only surviving son at this point, Buster. What will the defense benefit from calling him to the stand?
He's going to call Buster to the witness stand? Well, it depends. I mean, he obviously knows what Buster's going to say more than I know and what he's going to extract from him. But anything that helps him establish that there's a reasonable doubt. So I'm not sure what that testimony will be. As I was talking the last time I was here, you call witnesses that you can get evidence from that's going to help your case. And I mentioned earlier that I actually had a case where I called the mother of the decedent and the father of the decedent and the daughter, because that's where I found the evidence. And it's a difficult thing to do, but you got to call the people who have the evidence if no one else has it.
Let's talk about some of the evidence hearings that they held today. In fact, we have a viewer question from one of our viewers named Deborah, and I want to give those who did not sit at their computers or TV today a little background. There's a ballistics expert from SLED. The defense does not want this person to testify, and so he did testify just for the judge today, purely for the benefit of the judge to make a decision about whether his testimony will be allowed in the trial. And so Deborah's question is essentially asking, why do they not want him to testify? Why would they oppose this defense expert? Why is the defense trying to suppress evidence regarding the blood spatter by limiting testimony from the crime lab? So all of that kind of relates to the blood spatter, but also the ballistics evidence as well.
Well, Deborah, here's the answer. Obviously, if you're the defense, you want to keep all the evidence, as much evidence as you possibly can, out that they're going to use against your client. You want to keep it out, and you want to make sure as little evidence as possible comes before that jury, particularly something as substantial as the ballistics, dealing with the guns, anything dealing with the blood spatter. Those are critical pieces of evidence in this case. So clearly he wants to keep that out.
And we also had another viewer question from Norma, if we can pull that up. She's asking a question that this news is nationwide. So we talked a little bit about this yesterday, but should that not make it even harder to select a jury?
Yes, and that's exactly why the judge summoned 900 potential jurors. And I'm actually surprised to find out that here we are day 2, and it looks like they may be finished with jury selection in 2.5 days. By tomorrow, they will probably be finished with the jury process. And that's really shocking. So you can only imagine how many people who either decided they could not be fair and decided they don't want anything to do with this case. And now we're in the process of, the case is probably going to start tomorrow afternoon.
Well, and it's worth noting that at one point in the courtroom today, they asked everybody to raise their hand if they had heard about the case. And one reporter said everybody raised their hand. So that will be an interesting development to follow. As we look at this pool now of qualified jurors, and they do the work tomorrow to seat the jury, 12 jurors and 6 alternates. I'm going to ask you to flip the script and put a prosecutor's hat on for a moment.
Sure. What
considerations are you making, would you make as a prosecutor in terms of selecting those jurors to put on that jury and decide your client's fate?
That's an old hat you asked me to put on.
I did.
Takes me back to the JAG Court days. I'll tell you, what I'm looking for if I was a prosecutor clearly is somebody who is going to be stern, all right, and somebody who's going to make sure that they listen to the evidence that I present and not buy into the eloquent arguments that I know are going to be made by the defense. I want them to focus on the evidence because I believe I have a good case, and they will get in that deliberation room and lead the jury to the verdict that I want to receive.
You don't want them to be led by the emotional arguments that we already started hearing from the defense team today.
Exactly.
Yeah. Well, thank you so much for coming on and explaining that to us. Of course, we will continue to speak to trial lawyer Carl B. Grant every day as this nationwide trial is going on, is being watched across the nation. A lot of people have interest in this, Judy, and we will continue to make sure that we get your viewer questions answered.
We absolutely will. Some of the video that we were seeing there was that sled expert who was on the stand today. He talked a lot about his qualifications. He also talked about the process they use. So I'm not sure Judge Newman has made a decision yet about whether to allow his testimony, but all of these pretrial decisions are going to be critical in how this plays out.
I used to say that pretrial motions is the washing machine that scrubs the case.
Okay.
Okay.
All
right.
Good way to
And I used to file so many motions, they'd call me motion sickness. So yeah, you got to get the pretrial motion so that you know exactly what you're dealing with.
All right. Well, thank you for helping us walk through this process and understand the legal process as it plays out.